Hello and welcome to this edition of Let's Talk Human Rights, the video and podcast series from the Maastricht Centre for Human Rights. In this series, we talk to human rights researchers about what they do, why they do it, their work, and human rights issues that have the potential to affect us all. Now, you may already be aware that when it comes to the implementation of human rights, so making human rights effective in your day-to-day lives, courts, including international courts, play a very important role. But how exactly do these systems work? When it comes to international courts, can the resistance of states have an influence on how effective that implementation is? To discuss these questions and many more, we have with us today two researchers from Maastricht University, Naz Yılancıoğlu and Craig Eggett. Naz, would you like to introduce yourself?
Yes, of course. First, I would like to say I'm really happy for being here. My name is Naz Yılancıoğlu. I'm a PhD candidate in Public Law Department at Maastricht University. Originally, I come from Turkey. Before my PhD, I received my first LLM degrees from Queen Mary University of London. And then I completed my second master's degree at Ankara University. Right now, my research concerns about the execution of judgments of the European Court of Human Rights in national legal orders.
Thanks. And Craig?
So I'm Craig Eggett. I'm an assistant professor of international law at Maastricht. My research was previously on theoretical questions, lawmaking, but now I focus on two main areas, which is dispute settlement between international courts and tribunals, and making new international rules to regulate that, essentially the procedural rules for these bodies.
Nice. Very good to have you both. One thing that I quite like to ask at the beginning of these sessions is to get a better picture of how you got into this area of research. So what was it that made you want to do this? What was it that made you want to research this particular topic, but also, why research? So maybe Naz, you'd like to start?
Yeah, I would like to start. To answer this question, I need to talk about my bachelor's years because during my bachelor, I used to think about enforcement of the European Court of enforcement of the European Court of Human Rights works very well. For example, if the court find a violation of the convention, I was thinking everything was done. But then, especially during my master's degree, I realized the practice is really far away from this. All member states of the Council of Europe have experienced delays, but in the different extent. Also, in some cases, judgments are never executed. And for this reason, I realized the importance of the topic, and I thought this topic deserves more in-depth research, and that's why I'm here, and I would like to conduct a human rights research.
Yeah, thanks. So that's really interesting because we see already that there's like a gap in enforcement there. Yeah. So, you think it's already done because you've got a judgment, but whether that actually has an impact, that's a different question. So we'll get into that for sure soon. Craig, how did you end up doing the research that you're doing?
So I think like lots of international lawyers, like lots of human rights lawyers, we think that what we do and the field we're in has an inherent benefit, is something that is generally good, and lots of human rights lawyers, international lawyers, are concerned with sort of making the system better, trying to make it work a bit better. So some people do that on a sort of on a higher level, and some people do that with the nuts and bolts of how the law and the system works. And I'm in that category, trying to make sure that trying to think about ways that these bodies can work more effectively, that the system can make more of a difference. Like you said in the beginning, sometimes enforcement is a problem, as Naz said. This is something that is clearly an issue. So it's trying to think about how we can best solve those problems with law as part of the answer. Sometimes the complete answer, sometimes a very small part of the answer, but at least as part of the answer.
So I think maybe for those at home to get a better idea of how these things work, I'd quite like to ask you just to tell me a bit about the bodies that you study, so the courts that you study and how those systems work, so that everyone at home can have can have an idea of the system and what we're talking about when we talk about these different parts. So maybe, Naz, you'd like to start with the European Court of Human Rights, because that's your focus.
I think in terms of the European Court of Human Rights, there are different bodies to provide timely, effective execution of judgments. The first step, the court should have decide a judgment about violation of specific human rights, and then these judgments should be submitted to the Committee of Ministers to monitor the execution of judgment. The Committee of Ministers is the main body to supervise the execution of judgments in the European Convention on Human Rights. The European Court of Human Rights is a regional human rights court, and the main aim is to protect and promote human rights. In this regard, the Committee of Ministers supervises the execution of judgments. We can talk about a process. The Committee of Ministers supervises, and also states provide information whether states implemented the judgment or not. And then the Committee of Ministers, if the Committee of Ministers decides that state executed properly, this examination will be closed by the Committee of Ministers.
Okay, so we have a situation where the court makes a decision as to whether or not a state is complying with human rights, and if not, what they should do. And then we have another body, the Committee of Ministers, that essentially monitors that and makes sure that that is enforced. Is that kind of system similar to the different courts we have in international law, Craig?
It's not. And firstly, the courts I study are not directly related to human rights in the same way as the ECHR, as the European Court. So the two bodies I study are sometimes confused because they've got relatively similar names and they're both in the same place. So it's the International Criminal Court, the ICC, and the International Court of Justice, the ICJ. Now, the main difference between these is that they concern different parties. So the ICJ, the International Court of Justice, is when there's a dispute between states. So two states have a dispute, such as Russia, Ukraine, about a particular issue. They would go to this court, provided the specific requirements are met. But the International Criminal Court is, as the clue is in the name, a criminal body where cases are brought against individuals. So not against countries, but against individual people who commit some of the worst crimes, such as genocide, crimes against humanity, and war crimes. So the main thing I think that is the main difference here is the monitoring of these decisions, the implementation of these decisions. There aren't these two bodies. There are these standing courts, which of course internally have different parts and different organs. Yet getting there before these courts and getting judgments enforced depends a lot more on states cooperating in individual circumstances, whilst at least you could view the ECHR more as states have decided to cooperate beforehand. They've set up this mechanism. There's far more there's far less freedom. Of course, there is still some freedom of states to decide what to do, as I'm sure Naz will explain. So that's the main area. And remember, these are courts dealing with different things. So one on criminal bodies, and one on disputes more generally, which could be about anything. It could be about the sea, it could be about human rights, it could be about territorial disputes, it could be about absolutely anything. So human rights, of course, is incredibly important for each of these bodies, but they aren't courts specifically dedicated to human rights in the same way as the ECHR.
So I think that's interesting because, you know, when we think about domestic courts, you don't think about the parties to a case as needing to cooperate with the court system for it to work, whereas in international law and in with the regional human rights mechanism for the European Court of Human Rights, it does seem that you almost need the parties that are being judged, at least with the ICJ and with the European Court of Human Rights, to cooperate with the court. Is that also your understanding of the European system, or the ECHR system?
Yeah, actually, first I need to say under Article 46 of the Convention, all member states of the Council of Europe have legal obligation to abide by the court's final judgment. First, this is a legal obligation. This is, for example, not a kind request from an international or regional body in terms of the European Court of Human Rights system. And but the Committee of Ministers is an intergovernmental body, and for this reason, it needs to also cooperation because, for example, it decides with 2/3 majority, and for this reason, also Committee of Ministers needs to collective enforcement to provide and promote human rights.
Yeah, and then when it comes to cooperation, what kinds of things at the international level are we talking about with cooperation?
So it depends on the body. So if we think of the International Criminal Court, I think probably the main thing that will come to mind is once this court issues an arrest warrant and is looking for a suspect, is looking for someone who's potentially committed these international crimes, it's the question of obtaining that individual, right? There isn't, if you compare as you did to the domestic system, there isn't a police force that will go around and knock on the door and find someone. This will depend on national authorities to cooperate. Now, just like at the ECHR, ICC, International Criminal Court, state parties have an obligation to cooperate, but there can be very difficult questions here. So there was a very long saga involving one of the sets of arrest warrants because states didn't know whether they could arrest a foreign head of state. So this is something that states, even when they try to do, could see other hurdles. But it's, executing these arrest warrants. If we think of potential arrest warrants against Russian leaders now in Ukraine, the question of which states are willing to arrest these individuals is obviously at the forefront. And then, of course, in executing these judgments, these are courts that decide things on the basis of law. So once there's a decision, there is at least in theory, legally binding decision. Yet once again, the follow-on enforcement of that can be very difficult. So it will require pressure from states, willingness on the state that is deemed to have done wrong to cooperate. So it's just a different system. You might argue it's less effective, but it's just a different system. Most states do comply with most of these judgments most of the time, but it's just a different way of going about it and a different way of exerting pressure because international and international human rights protection is structured differently to domestic systems.
So we say that, this is a different system, maybe a less effective system. Maybe this is a difficult question, but why would you say that we have this kind of system? Why are we dependent on state cooperation? Why don't we just have a system where, you have a kind of top-down enforcement of judgments from courts at the international or European level?
I think it's because you're regulating an inherently different society, right? So in domestic systems, we as residents and citizens of the Netherlands have a vertical relationship with the state. There's state organs that regulates all the different actors in society. But in international law, you have a very different system. You have sovereign equals. You have no top-down authority because states have not decided that that's the way in which they want society to be structured. So everything is far more horizontal. Everything is far more decentralized. There are lots of different courts, as we already see, dealing with lots of different issues all over the world. There are other regional human rights bodies. There are other international courts and tribunals. So the society is different, and so the legal system is different as a reflection of that. As I said at the beginning, I think we as international lawyers need to be, and human rights lawyers need to be constantly thinking about how we can make this system more effective and work towards different structures. But I think the answer to this is simply because the society that's been regulated is just so different from the societies we know on a day-to-day basis in national law.
And we say that these systems are mostly effective most of the time, or that states comply most of the time. But I'm thinking particularly in the European system, do we see cases of states resisting those judgments?
Yeah, of course. It's there is a resistance. I can say clearly there is a resistance because the Committee of Ministers since 2007 published every year the annual reports, and we can see this resistance with these reports because we have clear statistics about non-execution and delayed execution. And there is a particular resistance. The reason could be, for example, unwillingness of the member states, of the lack of clarity of the courts. There could be many reasons, but for this non-execution and delayed execution, many individuals, unfortunately, will not have their rights.
And are there mechanisms for, I don't know, for states that consistently resist judgments?
Yeah, actually, the Committee of Ministers has some working methods to monitor execution of judgments, and we can see all these mechanisms under Article 46, paragraph 3 and 4. But unfortunately, they are just monitoring mechanism. In the European Convention on Human Rights, we don't have any specific sanction. We can go to the Article 8 of the Statute of the Council of Europe, more generally, and there are some sanctions. For example, suspend of membership, or just cancelling of membership even. But also these sanctions are really extreme, and until today we haven't seen any practice of this implementation. Also, they are really extreme thing.
Yeah, okay. I wanted to talk a bit about, because I think this resistance question is interesting, and the relationship between kind of states resisting and the state trying to sort of protect their own sovereignty, because I think often that's the argument that states use, right? Is that they should have the right to make certain decisions about what happens within their own state versus an international court telling them what to do. That's often the state perspective, and I think from what I understand from both your research, we have kind of in the European Court of Human Rights system, this concept of subsidiarity, and then in the International Criminal Court system, at least complementarity, which I think there's an overlap between those two. So maybe, Naz, could you maybe explain at least what you think is meant by subsidiarity and how it works in that system?
Yeah, of course. The subsidiarity principle means the states have the main responsibility to provide and promote human rights, because the Council of Europe consists of 46 member states, and these all member states have different, for example, legal tradition, legal culture. They share some common understanding for democracy, human rights, and rule of law, but apart from they have some differences. For this reason, the courts developed a principle. This is the subsidiarity principle with the margin of appreciation. And in this case, until 2021, it was a court's case law principle. But right now, we have also this principle in the preamble of the European Convention on Human Rights with the protocol number 15. And it provides a space for the member states. First and foremost responsible is the states. Yeah, this is also for the execution of judgments, also in generally for the human rights.
So it's kind of almost a sort of shared responsibility between the European Court of Human Rights and then national states deciding within a certain parameter how they're going to implement human rights within their own territories and for their own citizens. Is that obviously it's a different system, but do you see kind of overlaps with complementarity in the International Criminal Court system, and how does that work?
Yeah, I think there are certainly overlaps, and reinforces the idea that international law doesn't just happen in international courts, right?
Yeah.
International law also happens in domestic courts, and it's really important that it does. So complementarity at the ICC. So if we think about the history of how we've dealt with things like what the ICC deals with, which are gross systematic human rights violations, and this idea that we hold individuals responsible for them. So this comes from Nuremberg and the Tokyo trials after the Second World War. We had the ad hoc tribunals, as they were called, for Rwanda and Yugoslavia in the 1990s. And then we make it to a permanent international criminal court. There are other bodies, but that's the main trajectory of this area. Now, many of these other bodies, like Nuremberg, like the Yugoslavia Tribunal, were structured on this idea of primacy, that these courts, first and foremost, should be the ones dealing with these cases. The ICC works very, very differently to that and has some similarities to subsidiarity. The whole idea is that first and foremost, it should be domestic courts dealing with this, and only when a state is unwilling or unable to do so properly, to properly investigate and prosecute these crimes, will a case reach the ICC. So it's a sort of safety backup, if you will, when domestic authorities can't do this. So we've seen this a lot in the news recently. The ICC has been referred to quite a bit for prosecutions of individuals following the Russian invasion of Ukraine. Yet, something that I think hasn't received as much attention is that domestic prosecutions have already started in Ukraine. Mm-hmm. So we're already seeing the state take its primary responsibility there. And bring cases, and the case was a guilty plea that will result in conviction. So the whole idea is that the ICC is, as you can see from the name, complementary to, and only hears a case when it cannot be heard at a domestic level.
And do you see both subsidiarity and complementarity in these different systems as a predominantly positive thing, or are there problems with how that works in the implementation of human rights or international criminal law?
I think maybe as a purely practical matter, it's not only a positive thing, it's necessary, right? Mm-hmm. Already if you take the International Criminal Court and the ECHR, there's always comments on the workload, on the caseload before these courts, even in a system where they're secondary to domestic systems. The relatively small caseload of the ICC, for example, all chambers are overworked. Can you imagine what that would be if they were hearing every potential case of international criminal law, international human rights violations, European human rights violations from all of these states? It would simply be unworkable. So I think merely from a practical level, it's a critical thing. I think it also is important that these bodies provide some sort of oversight or symbolic in improving the domestic protection of these human rights and from international crimes.
Mm-hmm. Yeah, I'm completely agree with Craig, because the aim is to provide human rights protection in home country. For this reason, if we have empowered human rights protection at the national level, it will be also helpful for the caseload of the courts, I think.
Yeah, so it's also partly kind of about integrating these standards in the national systems as well as imposing them from above. Okay. I wanted to ask, now we've been talking about these systems for a little while, about visibility and transparency of these bodies, because I think it's very interesting that often these bodies are making decisions that impact individuals, that impact, individual people like you and me who live across Europe for the European Court of Human Rights, or across the world for the ICJ and the ICC. But a lot of people aren't aware of these bodies. Do you think that distance is a problem? And do you think that the systems are sufficiently transparent?
Mm-hmm. Maybe, I can start with in terms of the European Court of Human Rights system. First of all, there are different actors. Firstly, court, and then Committee of Ministers. I can answer both of them. I think court's working method is really transparent, because we have HUDOC website, and we can find all statistics, all communication from this website.
And this is just open to the public?
Open to the public. For example, if somebody want to look to these statistics, these judgments, communications, it's completely open to public. But also, the one of the for me the good side of the court, applicants can bring their complaints with their own languages. For this reason, there also there is no any language barriers. In terms of the Committee of Ministers, Committee of Ministers consists of the states' representatives, and this is actually an executive body of the Council of Europe. For these reasons, historically, all meetings are confidential.
Okay.
Actually, this is a bad side for the transparency. But in the recent years, since 2007, we have had annual reports. These annual reports provide more transparency because we right now have statistics about non-execution or delayed execution. Also, we have the meeting reports. After all, Committee of Ministers have 4 meetings every year for the execution of judgments regularly, and we have reports of these meetings and also agendas, and also the Committee of Ministers have communication from NGOs and national human rights institutions. Right now, they are also open to public in the website of the Committee of Ministers.
Okay, so we do have some kind of transparency mechanisms and ways in which people can find out more about the court. Is that also the same with the ICJ and the ICC?
I think the information is there. I think information on how these courts work is there. Sometimes are these sites as good as HUDOC, which is an excellent resource? Maybe not. But they're certainly improving, and the information is there. The proceedings are typically broadcast live, and there are these records of these cases. I think a main difference, though, is that the ICC and the ICJ deal with things that don't touch our everyday lives to the same extent as the ECHR in Europe, of course. We're dealing with disputes between cases that maybe involve disputes between states, that maybe involve human rights, or we're dealing with extremely grave, very serious, systematic violations of human rights. So these things typically don't affect everyday life in the same way as the ECHR. That being said, I would say that, again, in the recent example of Russia-Ukraine, we are seeing more than I remember in the last few years, more of a discussion of these bodies, more of a discussion of what law can do in response to very clear, egregious human rights violations, which is a reassuring sign. You're seeing reference to the ICC, you're seeing UN human rights body meetings, you're seeing talk of ICJ cases, you're seeing this kind of discussion of law. That doesn't necessarily mean that the law will be effective and the law will do what it's supposed to do, but that is a reassuring sign, I think, and we should be encouraging this, and we should be trying to use law as a tool in such context. So I think it's just making law part of the discourse and part of the discussion in these situations. But the information is there, and I would encourage people to go and look at this information and watch these cases and see law in action and see these international efforts to protect human rights and further international law.
I think that's a very good note to start to bring this into a close, because we are coming to the end of our time, unfortunately. To finish, I like to ask everyone that takes part in this video series and podcast series to be as serious or as silly as you would like. If you could add one new human right to human rights law, what would it be? Naz, I'll start with you.
Okay.
It's a difficult question.
Actually, this is a nice question. We have opportunities to create a human rights. I believe everything starts with dreams. For this reason, I would say the right to follow your dreams.
That's beautiful.
Yeah, because these days, sometimes we forgot to dream. And firstly, I think we should have dreams, and then we all have the opportunity to equally to provide to follow our dreams. But I wish this right, especially for all women around the world.
A right to follow our dreams.
Yeah.
Are you going to top that, Craig?
I'm not sure I can, to be honest. I think that's a very good one. Yeah, I'm not sure if I can think of one thing jumps out as a human right to me. I think, though, when we're thinking about human rights law, I think there are sort of two things there. Firstly, to make sure that they reflect society and they reflect what we're trying to do. Some of these human rights are very old and might be not fit for purpose. So we need to think about what they actually mean, what they actually contain, and to link it back to the topic, that they're actually enforced, that we can actually do something with this and see them protected. So I think it's just thinking more about how we use them. I don't have anything as beautiful and poetic as Naz put, I'm afraid. But I think we just, as always, need to be thinking about how we actually achieve the protection that we're looking for.
I think that's a good mix. We have the poetic and the practical together. We'll save the world. If people want to find out more about you and your research, where can they find you, Naz?
I have a Twitter and LinkedIn accounts, and I'm using both of them actively. And also, I strongly recommend the website of Maastricht Center for Human Rights and Montesquieu Institutes, because there are really nice articles, information about human rights.
And Craig?
Yeah, same. So LinkedIn and Twitter, @Craig Eggett. Also on the Maastricht Center for Human Rights, there's a specific section about the International Law Discussion Group, which I run, which has lectures and seminars and research events all about the international dimension, international law generally, but also the international dimension of human rights and international criminal law. So you can find out more on the pages there on the Maastricht Center for Human Rights.
Thank you. I want to thank you both. Thank you, Naz. Thank you, Craig. Thank you very much for being here and for this conversation.
Thanks.
For everyone at home, as always, if you want to find out more about what goes on at the Maastricht Center for Human Rights, you can look at the Maastricht Center for Human Rights website. I'm Sally Thin. I've been your host, and we will see you next time.